to you what she's talking about, and that's this, that if you are going to challenge a rulemaking, or if you're going to challenge the results of a rulemaking, whether it's the county commissioner level, or it's at the state level or the federal level, you have to participate in that regulatory process. Yeah. So what happens is, let's go back to the federal level. Let's talk about the EPA. This week the EPA is attempting to take jurisdiction over all waters in the United States pursuant to the Clean Water Act and write the word navigable out of the Clean Water Act. Under the Clean Water Act, the EPA, the federal government, only has jurisdiction over those streams that are navigable. And the reason for that is that the federal government really should only be looking at the bigger streams, a North Platte River, a Laramie River, a stream that is going to have a larger impact on a larger area. And so what they're trying to do, though, is they're trying to take jurisdiction over irrigation ditches. And they are taking jurisdiction over prairie potholes. And they are taking jurisdiction over a slough that may not have, a slough that may not have water in it except once every 15 years. As you see different water bodies with as much rainfall as we've had this year, as you see water bodies out in areas where you've never seen them before, simply because of the amount of rainfall, groundwater table is rising, it's holding water for 2, 3, 4 days when typically it would drain off. They're starting to take, the federal government is trying to take jurisdiction over those water bodies, even though the statute prohibits them from doing that.
Yep.
But what they've done with this latest rulemaking, and it's one of the largest rulemakings they've ever done, but what they've done in terms of impact, what they've done is they've tried to write the word navigable out of the statute. I believe the courts are going to push back. I believe the courts are going to stop them.
We can hope so.
Did the bureaucrats or Congress put the word navigable in
Congress. It's in the Clean Water Act.
That's
the
Congress's word.
That is Congress's word. But here's what has happened over time, is that courts have allowed agencies to rewrite the law under the auspices of rulemaking.
Yep.
And so what the courts have done is they've said, we are going to defer to the agencies. So the EPA, their jurisdiction, their expertise is under the Clean Water Act. They have an entire division that deals with water issues. And so the courts have said, we're not going to second guess what an agency does. If an agency believes that it needs to take jurisdiction over this water, we're going to allow them to. Until 2006, that the EPA and the Corps of Engineers have gradually increased their jurisdiction or their claimed jurisdiction over various water bodies throughout the United States. In 2006, the United States Supreme Court issued what's called the Rapinos decision. And when I was here last fall, I read to you part of the Rapinos decision. And it talked about how basically the entire United States is now under the jurisdiction of the EPA under the Clean Water Act, whether there's water there or not. They take jurisdiction over ripples of sand in the desert that may have water once every 100 years. And that's what this latest rulemaking is. And so to get back to my point of what I was going to say to you, in order for us to challenge that rulemaking, in order for anybody in this room to go in and file suit under that rulemaking, you would have had to have participated in what's called the regulatory and rulemaking process. So that's why I came up here today, was to talk to you about what you have to do to get involved.
Very good.
You have to know when these rulemakings are coming down, and all of them have to be published, both at the state level. I'm not as familiar with the county side of this.
Right, right.
And so I'm not going to speak on that because I don't want to say something that is incorrect because I haven't looked at your zoning code, I haven't looked at the rules and regulations. I'm going to talk more from the state and federal standpoint. But what happens is, let's take the roadless rule as an example. The roadless rule was conceived as the mechanism by which they were going to give Bill Clinton his legacy beyond the legacy that we all remember very well. And they were going to give him the legacy of the roadless rule. The roadless rule was designed to deny access, management, and use to 58.5 million acres of national forest lands in the United States. Now keep in mind, the national forest lands in the United States are made up of 192 million acres. They were created in 1896 under the Organic Act, and the Forest Service was created within the Department of Agriculture, not the Department of Interior, because they looked at our National Forest Service lands as lands for commodities. They were to create a continuous supply of timber and a continuous supply of water, because that's where most of our headwaters are, just like we have in the Medicine Bow National Forest, the Shoshone, the Teton, whatever it is. That's where so much of your snow melt comes from. That's where we're a headwater state. We have some of Colorado and Wyoming have the most interstate streams of any states in the nation because we've got the Rocky Mountains. But anyway, when they created the National Forest Service, it was created out of 192 million acres, put into the Department of Agriculture, not the Department of Interior, and they were to be managed for timber, livestock production, and water. Well, over the last 30 to 40 years, as we all know, with the Multiple Use and Sustained Yield Act and all of the environmental regulations, the Forest Service has regularly been taking more and more and more lands out of production and use. The roadless rule, added in with all of the Wilderness Act lands and things like that, now over 60% of all of our National Forest Service lands are off limits for any kind of use. And the roadless rule is actually more stringent than the Wilderness Act is. And the Wilderness Act is one of the most stringent laws you will ever find. But starting late in 1999, the idea came up, we'll do what's called the roadless rule. And I actually was hired by the state of Wyoming eventually to sue over this, and I was able to get some discovery and find out how they put this together as quickly as they did. But basically the rule was written in the back rooms in Washington, D.C., and some of the names that are continuing to come up today, such as John Podesta, and folks like him were in the back room with the environmental groups writing the roadless rule. And in August of 1999, they essentially wrote the roadless rule. And it was, at that time, the largest rulemaking in U.S. history. It was never released for notice and comment until October of 1999. They had, I think, maybe 15 public meetings in November and December and January of 2000. They went into immediately, they first did a notice of intent for the rulemaking. They immediately went into the draft environmental impact statement. They immediately went into a final environmental impact statement. And we had a final rule by December of 2000. It took them a little over a year, and it was one of the reasons we sued, because affecting 58.5 million acres, it's not even possible for them to have gone through that regulatory process that quickly. But what they did is they had all of the skids greased, and they had all of the environmental groups ready to go. And as soon as they announced, it was on October 19th, 1999, that they announced the notice of intent to study this roadless idea. As soon as they announced that, and it was going to cover 54 million acres originally, it had already been cooked in the books. And what we found was that when they finally did do public outreach, and they had a couple of public meetings in Wyoming, because we have over 9 million acres of National Forest Service lands in Wyoming, and we have over 3 million that are now subject to the roadless rule. 3.2 million in Wyoming. Huge areas of land that were designed to just literally stop any kind of development, use, access, grazing, anything else. So when they did that, what we were finally able to do, we filed what's called a Federal Advisory Committee Act claim. When we did that, we were actually able to do discovery of all of the environmental groups as well as the federal government. It was the first time in history the federal government had ever had their rulemaking subject to discovery. But what was the most important was I got to go through the environmental group's records.
Awesome.
So the other side was represented by Earth Justice. It was the Sierra Club, Natural Resource Defense Council, a whole variety of them, probably 8 or 9 different environmental groups. And what I found in their files was that they had their entire strategy written out, because they never expected anybody like me would be able to go through them. But again, I was hired by the state of Wyoming to sue over that rule. And what we found was when they had their public meetings in Worland or in Riverton or in Evanston, They would come into a room like this. The meeting would be public notice. Let's say it's December 9th, 1999. Very short period of time of this public notice, and it's public. It should be in the newspaper, and there's supposed to be information about this being published. But they would hand a clipboard. They would hand a clipboard, and you had to sign in. And so if I am working for the Forest Service, I know who my environmental groups are. I know who my folks are who are in the room. A lot of them were paid.
Oh, yeah.
They were paid operatives to come in and claim that they were
Paid
from...
by whom?
By the environmental groups.
Okay, not
And
the
most likely,
taxpayers.
well, no, they
But
probably were by the taxpayers because
There
a
isn't
lot
an
of their
environmental
money,
group that
a
doesn't
lot
have
of
their
their money
fingers in the
comes from
Yeah,
the
well, I
federal
understand
government.
that. They get kickbacks in the,
A lot of their
court
money
cases.
comes from the federal government. So anyway, what they do is they would take the clipboard, and they had people scattered throughout the entire room. They're not going to give the clipboard to Harriet Hagemen. Harriet Hagemen's an enemy of the state. They're going to give the clipboard to the people that they want to be able to speak. So if it's a 3-hour meeting, they're only going to be able to have 20 to 25 people speak. 30 people speak. So I'm reading these reports from the Forest Service saying we had 117 people in Riverton, and 98% of them spoke in favor of the roadless rule.
Yeah.
And I thought, that does not make sense to me. That does not make sense to me. And when I got into the environmental group's records, I finally figured out how they did it.
Wow.
The other thing that they did is, as you know, Smokey the Bear can only be used by the National Forest Service. That's a logo that can only be used by law, by statute, by the National Forest Service. But what they would do is, let's say that the public meeting was scheduled for 5 o'clock at night. At 3 o'clock in the afternoon, the Sierra Club would rent that same room. And they would put all of their stuff all the way around the room. Let's save the heritage forest area, protect our national forests. And they were using Smokey the Bear.
Yep.
Then at 4:45, they take their stuff down, Forest Service puts their stuff up, you can't even tell the difference. You can't even tell the difference between the two, even though the Forest Service is supposed to be neutral. So what we found, what I have found, is that this whole regulatory process is very stacked against the people who really should be participating at the local level. Just to give you another example, I have fought the wolf issue since 2002. I was hired by a group of quite a few different organizations. I refer to them as the Wolf Coalition. We filed our first lawsuit in 2002 over that. I've attended many public hearings about the gray wolf, about introduction of the gray wolf into Yellowstone National Park. I was attending a public meeting in Cheyenne, walked out the door, and there were 3 Greyhound buses in the parking lot. And the people who spoke were not from Cheyenne. They were not from Wyoming.
Nope.
They're bussed in from CU.
Yep.
They're bussed in from Boulder. The Sierra Club paid them to come in. They volunteered to come in. But that's how this regulatory process has been distorted over the years. But what you have to do is you have to participate, because if you don't participate in the regulatory process, you have no standing to sue.
That's what he said.
So again, on this issue of the E.P.A., the Clean Water Act, we have a variety of clients who have written letters over the years, and they have participated. They've commented. This is a letter from the Wheatland Irrigation District that we've assisted in writing to the E.P.A. And you identify what you have to do is you have to identify the rulemaking, you have to identify why you've got an interest in it, and then you need to explain why they either should or should not adopt that rule.
Get that?
And then when they, and you can look at this, and I've highlighted what I think are some important aspects of the letter, because what it says is we're respectfully submitting these comments, we identify what the rule is, we explain who we are. Wheatland Irrigation District is located approximately 70 miles north of Cheyenne. We irrigate 54,000 acres. We have 830 users. We have a vested interest in the proposed rules, which will directly affect our means of operations. And then we identify what our compelling interests are. We go on to describe how it is going to affect us, that it's going to be a higher or larger regulatory burden. There is the possibility that we would have to consult with the EPA or Corps of Engineers every time we want to change an irrigation ditch. We explain the number of acres that are potentially affected by this rule. In this one it says it's 106 million acres will be affected by this new rule. It talks about the impact to us being increased regulatory costs, bureaucratic barriers and penalties disproportionate to the size of the body of water. And then it talks about what the potential risks of this rule are. Keep in mind, under the Clean Water Act, the fines are $37,000 a day. So if you violate the Clean Water Act, they can actually go after you. I tried a case a year ago, and I talked to you guys a little bit about it when I was here in October. David Hamilton. Hamilton moved an irrigation ditch. And the EPA and Corps of Engineers went after him. He spent $1 million defending himself between attorney's fees and expert witness fees. And last April, after a 2-week trial, the jury came back in his favor. We won. Wonderful. But they found that he had not violated the Clean Water Act. But at one time, the fines against him were over $62 million at $37,000 a day. $62 million, and we were ultimately fighting over 2.1 acres. The total acreage that we were fighting over, according to the feds, was actually smaller than that, but I'll give them their due on that one. According to the federal government, we were fighting over 2.1 acres. And because of the power that they have of that $37,000 a day in fines, it racks up awfully quickly. Now, what I'm going to say about that is I've never heard of a case where the EPA or Corps of Engineers successfully sought or pursued $37,000 a day in fines. But what's significant about that number is not whether they would have ultimately sought $62 million from him. What it is that the agency uses that kind of power and those kinds of numbers to bully everybody into compliance.
Yep.
How about blackmail? It's a better word.
Blackmail is perfect. I will use blackmail too. But what they do is when you get the notice of violation, we received the notice of violation in the spring of 2008. When we received that notice of violation 3 years after he'd done the work, it says right in there, you are subject to fines of $37,500 a day for your non-compliance.
Yep.
We will give you 10 days to send us a letter and let us know whether you are going to cooperate to fix the violation that you have engaged in. So it is a mechanism that Congress has given these agencies to completely abuse their power and to blackmail people, citizens of the United States, into complying with laws that, number one, don't apply, number two, shouldn't apply, number three, are ridiculous, and number four, have nothing to do with protecting the environment. And I could probably come up with about 15 other, number 5, number 6, number 7, if you just give me a few seconds. The fact is, the project that David Hamilton did substantially improved the environment. He decreased the amount of pesticides and herbicides he was using. He decreased the sediment into the Bighorn River. I remember standing on the bank one day with the U.S. Attorney looking at this fabulous project that he had created. And I said, you have to admit he did a beautiful job here. And he says, yeah, if he'd had a permit, this would have been a great project. And I said, but the permit doesn't do anything. The permit is irrelevant. If you care about protecting the environment, the permit is a piece of paper. And he said, it's the law. So, coming back to this idea, what happens is that when there's going to be a rulemaking, when there's going to be a notice of intent, when there is going to be a proposed rule, a modified rule, amended rules, they have to publish them. They have to publish that information in the Federal Register. Again, going to the federal level.
Right.
The Federal Register is where that information is published. Now, how do you find it? How do you find this out? Well, I'm going to tell you something that my firm has put together. It's actually a separate business I run. I'm not telling you this because I'm telling you you need to join the group that I work with. But we realized well over a decade ago when we were working on the roadless rule that the cards are stacked against us. That the environmental groups, it is their profession. It is their moneymaker. It is how they are in power. It is why Earth Justice pays their board members $100,000 a year just to be on their boards. It is why the Sierra Club is worth over $1 billion. This bureaucratic nightmare that we're talking about has made some people very, very wealthy. And we need to understand on our side, there's a couple of things we need to do. One, we've got to get I know you guys believe this too. I know I'm speaking to the choir, but I want to have some positive feedback because a lot of times I don't always get the positive feedback I want, especially from judges. So I'm going to say it anyway. We have got to change Congress and get them to understand that their job is to legislate, and we have got to stop them from giving the power to these bureaucrats and these agencies, which is what they've been doing for the last 30 years. Our representatives in Congress, probably on this issue, more than any other issue that is in front of them, have completely abdicated their responsibility in terms of making sure that the legislative branch has the power to legislate and not the executive branch. And I have finally come to a fairly cynical conclusion, which is I don't think most of the people in Congress want the responsibility for having to actually legislate. I don't think that they want to have to actually say about these agencies, we've got to stop this and we're going to stop it. How many times do you hear our congressional representatives from Wyoming as well as all across the United States, those doggone agencies, that E.P.A. out of control, that E.P.A. is out of control, that Department of the Forest Service out of control, the Fish and Wildlife Service out of control. Well, what do they do about it?
Nothing.
They continue to fund them. They continue to increase their funding every year. There's no accountability for the decisions that are made. I think that it is a perfect scapegoat for people who do not want to be held accountable for the decisions or the lack of decisions that they make. They go back there and they can say to me, Harriet, it's not my fault that the E.P.A. is trying to do away with what the Clean Water Act says. It's not my fault that your brother can't change his irrigation ditch. That's the E.P.A. But they're not doing their jobs. They are not doing their jobs. And I'm going to tell you that of everything that I see and everything that I do, and I deal a lot in federal court, I deal with a lot of federal issues, a lot of federal agencies, I do believe that what is happening in this country right now with this regulatory impact, what they are doing is the destruction of the republic that we have.
Yes, it is.
More than any other aspect of what is happening. You can point to a lot of issues that are not going well. But this is the one that is destroying our republic, because a republic is dependent upon people representing us. That's what a republic is. It is the consent of the governed. The point of a republic is the consent of the governed. I don't know. I don't have the ability to call the guy from the E.P.A. and say, don't do that. You're not coming on my place. You come on my place, I'll shoot you. I can't do that. I go to jail if I do that. That is what's happening with this. And sir, what?
We don't have a consent by the government. All Congress and all of our legislatures are members of a corporation. And they cannot make laws because they are a corporation. None of that is law, it's just rules.
I am going to see a gentleman speak next week who wrote a book called Is Our Regulatory Framework Unconstitutional? I should have brought that book with me. I meant to.
It is.
And it is unconstitutional, and I agree with you. The problem was, under Roosevelt during the 1930s, when the Supreme Court struck down his effort at big government and his New Deal, he sacked the Supreme Court. And since then, I will tell you that I've also seen a complete abdication of responsibility from the judiciary as well. You know, that's where it's become so insidious, and that's where it's become a, it's just completely destroying our form of government, because those kinds of power players are involved in decisions and doing things that are for their own behest or their own constituencies' behest, and we don't even know that they're playing in the game.
Well, we had that, Tour 23, has anybody heard anything about that? They're doing 23 counties in 23 weeks, And they came here, it was what, May 11th they were in town. So I went to theirs and there was probably 75 people in the room. It was a perfect Delphi meeting. Break everyone up into little groups. Everybody comes up with their own ideas of what Casper should be going in the direction. And it's all developers, it's all real estate guys. I think I was the only citizen in the whole room.
Was this the Wyoming Business Alliance?
Yes, yes.
Now, that's not government. It's not
Well, I know
supposed to
it's
be
not government, but you should have heard them boys. They were talking about going in there and changing some of the state laws to make it easier for them to do business. It was a plot. It was a plot going on in that room. And I was asked 3 different times what I was doing there. And I said, you invited the public.
Yeah.
Well, I'm here as the public. Well, who are you? I said, well, I don't think that's any of your business.
Yeah, I have not attended any of those. I do know that they were doing them. I just got out of a trial, so I haven't had an opportunity to attend any of those.
Yeah.
But I do know that they've been doing those around the state. And I agree with you. You can definitely see some of the same people. Now, everybody has the right to petition their government for redress. Everybody has the right to do those things. What is happening in our form of government anymore, though, is that instead of being able to stand up at a public meeting with Cynthia Lummis or Senator Enzi or Barrasso or any of them, we're not influencing them and having them listen to us in terms of what really needs to be done because of what's going on in Washington, D.C. You know, the reality is that our government is no longer working for us, it is working against us. And I think that if you did a truth serum to a lot of federal employees, I think that they would tell you very straight up, it isn't about you. You know, federal employees anymore are their own constituency, their own voting bloc. And I think that we're all crazy if we don't realize that, you know, I'll use Dave Friedenthal as an example. Dave Friedenthal was very smart in one thing, and what he did was he grew government dramatically. Not because he thought that government could do bad, the state government could do better than other things. He grew government very dramatically because he knew that there would then be a permanent voting class that would most likely vote Democrat. Matt Mead has kept the same folks in place.
Yep.
Matt Mead has not cut back on government. Matt Mead has not decreased the number of state employees. And what you've done is you've created at the state level even a constituency that is going to vote a certain way, not all the time, and I don't mean to talk in totally broad brushes, but in Washington, D.C., they know that the people who work for the federal government, whether it's the Forest Service or the Department of Interior or the whatever agency it is, they're going to be better off with the Democrat president than they are a Republican, or at least they believe that they will be. What?
I don't need to embarrass you, but I remember 25 years ago they had a jumping mouse down in Goshen County, and our 3 representatives came and they each whined for maybe 10 minutes, and then they said, now here's Tom Sansonetti, he's the Solicitor General for the
Department of Interior.
Yeah, Department of Interior, he's going to tell you guys how you're going to have to comply with this. And I went over to my brothers and I said, why aren't you over there listening to him? And they said, Tom Sansonetti is not going to tell me when I can irrigate or cut my hay or anything else to do with that.
Right.
So I think what we need to start talking more about is civil disobedience, because when you look at all this, that's the only thing that's going to work, and then come together and protect each other. And that's hard for an attorney to say, but I thought that was pretty funny. My brother said, your brothers too.
Well, and what was so crazy about that is that happened to be a species that in order to determine that it existed, they had to kill it. So the Prebble's jumping mouse is allegedly a subspecies of other jumping mice. But the only way to determine if it is actually a Prebble's jumping mouse is they had to measure the cranium. And to measure the cranium, they had to kill the animal. So what they did is they went into Platte County, Goshen County, and Laramie County, because that's where this species allegedly existed. And they trapped mice all over the place. And they killed them like there was no tomorrow. Yep, found another Prebble's jumping mouse. Well, thank you, you just killed the 10 that we had. But what it actually came down to, because I was involved in that one also, where Wyoming even came into it, because that was actually disproven by a gentleman out of Boulder by the name of Riley, I think was his last name, PhD, that it's not a separate subspecies. It's just like any other jumping mice. That his science doesn't matter. They didn't care. It is a listed species. The Preble's jumping mouse is a listed species. But Wyoming, they never found a Preble's. They never found a Preble's in southern Wyoming. The reason they designated those 3 counties as habitat for the Preble's jumping mouse was because they wanted to continue developing in Colorado where they actually found the alleged Preble's jumping mouse. So instead of stopping the development down there, because what did you just say? The contractors have a lot of money.
Yep.
They came to Wyoming, designated 3 counties as Preble's jumping mice, critical habitat, as mitigation for activities in another state. Now, again, Wheatland Irrigation District got in the middle of that one because one of the things they said we can't do in that rulemaking was burn ditches. You don't burn ditches, you don't irrigate. So we finally got them to pull back on that portion of the rule, but the only way we got them to pull back on that portion of the rule was to finally convince them that if we can't burn the ditches, we're going to have to use herbicides. Ooh, dirtier word than fire.
Oh, yeah.
So they actually changed the rule and said you can continue to burn ditches, but they never found a mouse in the entire state of Wyoming.
Are they doing that a little bit with the sage grouse situation too? It seems like those little designated areas move around according to the agenda of certain
Political.
people.
It is political.
Yeah.
And the thing about the sage grouse is, if they're endangered, why do we have a hunting season?
No kidding.
I mean, I still keep coming back to that. I really do. I keep coming back to that. And what is the #1 cause of sage grouse death?
Wasn't it other predators?
Predators.
Yeah.
Predators. Magpies. They eat their eggs.
Yeah.
Safest place for them is to lay their egg under an oil derrick.
I wish I had the statistics, speaking about that, I wish I had the statistics of the number of birds that are, and bats that are being absolutely slaughtered by wind turbines.
Oh, yeah.
Yeah, right.
Absolutely slaughtered. They hire people to go out and pick up birds every day.
And they're not even subject to the bald eagle or the bat or any of that. I mean, they're told they could kill up to 250.
That's what tells you
you
about
know?
how political all of this is. It is political, yes, sir.
I've seen the map of the United States. East of the Montana, Wyoming, Colorado, New Mexico, federal lands goes 1 to 5%. West, it goes about 36 up to the high 90s.
Yeah.
That's federal lands. Do you have a map like that of state lands?
No.
Do you have any figures like that of state lands?
Well-
What's the typical state land ownership on the east
Versus the west.
versus the west?
You know, I don't have those numbers. I can try to get some of those numbers, although I wouldn't have them for you tonight, but I can get some of those numbers. In Wyoming, state ownership is about 5% and the feds are about 45%. I actually am going to be putting up statistics tonight when we talk about conservation easements about land ownership in this country, and I might have some of that information in there, but I don't think it's as specific as what you're asking
Okay,
for.
the reason I ask is this. If it's,
None of us turned our phones off, it seems.
if the average in the east, say, is 10% state, and we have an average of about 60% in the west that's federal, and if that,
Well, you know why they want to keep it federal land, right? I mean,
if we
it doesn't
make
take a
that
genius to figure it
50%
out.
in the west compared to 10% in the east, because we take all this federal land and make it state, we still have a problem out of proportion. I'd like to see what would happen if we turned these federal lands over to private.
Well, and I don't disagree with you, but it's got to be incremental. This has got to be a step-by-step approach. And part of the reason that I say that is for the very reason that Kathy said a moment ago, which is your sportsmen and those groups and that constituency is going to scream bloody murder if there's any concept at all of turning it into private land. So it's got to be a step-by-step process, #1. And #2, while I agree with you, I still truly believe in the federalist construct. I believe, especially in a state like Wyoming that only has 600,000 people, as loud and as vocal as I can be, I'm going to have more influence at what happens at my state level than I ever will at a federal level.
Amen.
And so having those lands returned to the states, having the state have the authority, number one, the bringing that money back and keeping it in Wyoming instead of laundering our money through Washington, D.C. through the IRS code would be an enormous improvement. And I think it's one of the reasons why there is such a pushback against any
Well, it would
kind
be
of...
an improvement. Enormous, I'm not sure, with Meadenthal as the governor.
It may not be,
Meadenthal.
but he won't be there forever.
It might be a slight improvement.
Can I quote you on that, Mr. Cummings?
But the,
Yes.
but the,
You may.
the land and water is power. And you've got a federal government that we keep alive and that we allow to, as insidious as it has become on a lot of levels, it is the funding that gives it the power. You reduce the taxes, you have tax reform, because you're having the states manage these resources instead of the federal government, and it changes the balance of
Well,
power.
Tax reform is part of my platform also.
Yes. Yeah.
Choke off the money.
Do you want a break before you go to, I know you're
Oh, I don't care.
Are you okay?
Yeah.
All right, I didn't want you to.
No, I'm fine. Is it time to start our
Not
next?
yet, no, I just didn't know if you needed to, yeah.
No, I'm
Fine,
getting,
or something to eat or
So
whatever.
Misty, she talked for like 4 days straight.
You gotta give her, she's consistent though.
Over there around Jackson, these big ranchers like Rockefellers and that, and they die off, but they leave all their land to the federal government.
well, that is not a good idea, and I agree with you. And that is probably what I'm gonna be talking about tonight. Not so much leaving it to the federal government, but the manner in which we're actually federalizing our private property rights. There's a lot of ways in which the federal government is getting its fingers into things that it was never intended to. And I'll come back to the issue of federalism again. I do believe that our form of government works better than any form of government in the history of the world, in the sense of that we are supposed to be able to have our say in the government. We are, under the First Amendment, we have the right to petition our government for redress, whether that is engaging in the rulemaking process or filing a lawsuit or going down and walking into the governor's office and meeting with the governor. We have the right to do that. And in most of your governments, or a lot of your governments around the world, there is no access
Yeah.
like that. We have a form of government that is being destroyed simply because of the success of the federal government in expanding itself. One of the things that does give me some hope, a lot of things give me hope, but one of the things that does, and this is going to sound weird, we need to be talking about what has happened recently in places like Baltimore. Because to me, what has happened in Baltimore is, and Detroit and Chicago are the classic examples of a failed progressive viewpoint of the world. They're killing each other back there. They are slaughtering each other back there. They are living in anarchy. They're living in horrible conditions. They have unemployment at 50 and 60%. They have no hope. Their school systems are failing. And it's not because there hasn't been enough money spent on them. It's because the progressive viewpoint of the world doesn't work. Socialism doesn't work. It just flat can't work. And we have got to start doing, I think, a better job of pointing this out, that what is happening in Baltimore can be laid right at the feet of the Democrats in terms of 40 years of bad policies.
And half the Republicans,
Yes,
You're right.
at least half.
I think you're right. But they're failed policies. And it's coming home to roost. What happened in Ferguson, what Detroit, Chicago,
Ohio?
Ohio. But we don't talk about that enough, I don't think. I think we need to be talking about that more.
How much do you know about the Cleveland trial?
What are you referring to?
Was it a bench trial instead of a jury trial?
It was? You mean the police officer?
Yes.
It was.
That was smart attorney who made
That was a smart attorney that did that.
It's like a bad,
That was a smart attorney, but I'm gonna tell you something, that case did shock me. I mean, I wasn't there, I don't know what happened there,
The attorney might have known Greg or the judge, perhaps.
perhaps. Yeah, but that was the smart thing to do, to not ask for a jury. It was a police officer who was acquitted this week of a shooting in Cleveland.
Acquitted by a judge, not by a jury. Prosecutors cannot ask for a jury trial the way plaintiffs can. Prosecutors don't have a right to a jury trial. Defendants do, prosecutors don't. Plaintiffs do, and that's one of our major defects in our law.
Do you have any other questions?
I'd like to learn the rulemaking process and be able to address it immediately because it's out of hand. So I'd like you to talk more about how to be able to join your group and
Here's what I'm gonna do is, I can get this information to Kathy. I don't even know what a membership costs, and I didn't come up here to try to sell this. I really
know you
didn't.
didn't, but I would like to be a part of that. 'Cause
Okay.
I think there's a way to actually succeed.
The problem that we have is that there really isn't anything else out there right now.
Right, exactly.
And that's why I think that the state of Wyoming ought to be members of this. There used to be an office in the governor's office. It was called the Office of Federal Land Policy. And there was a woman in there by the name of Julie, and I can't remember Julie's last name. It's been about 15 years since I saw her. But Julie used to run the Office of Federal Land Policy, and what they did is something similar to what we do. She would review the Federal Register every day. And she would notify all the agencies of anything that was happening at the federal rulemaking level that would affect the Department of Ag or the Department of Education. She did them all. Again, I'm limited to water and natural resources, but if there was a rulemaking from the Department of Education, then the Department of Education was notified. And if you remember, one of the big controversies about Jim Geringer was he always said we are going to speak as one voice. And if you remember the Casper paper and the Democrats said you're violating everybody's First Amendment rights, everybody ought to be able to comment and say what they want to say even if they are a state employee. Well, Jim Geringer was right. What he said is every agency has the right to comment, but the final letter comes from me. So using the roadless rule, for example, the Game and Fish Department supported the roadless rule. Every other agency in the state did not. Our Forest Service did not, our Department of Ag did not, all of our other agencies did not support the Oil and Gas Commission. None of them supported the roadless rule.
Did they openly oppose it?
Yes, they all wrote letters. We had about 15 letters that were submitted from the various agencies impacted. State Engineer's Office, it's been a long time since I've read these, so I'm kind of taxing my brain a little bit, but State Engineer's Office, so they all wrote letters, and then the cover letter that went with it came from the Governor's Office. And the Governor's Office said, enclosed, please find letters from the following agencies, but here's what my position is too. That's what Geringer was talking about when he talked about speaking with one voice, and he was right. He was right. The governor ought to be the person who is saying, this is the state of Wyoming's position. He didn't prevent the agencies from speaking,
Right.
but he said this is what the position is. So the Office of Federal Land Policy made sure that we met all the deadlines and that we got all the comments in and that everybody got the information they needed. Within 1 month after Friedenthal took office, he did away with that particular agency. It was the only agency, I think, that he got rid of in his entire tenure. And he had Marilyn Simons. She was the head of the Department of Education. She was the superintendent of public instruction for several years, quite a few years, wasn't she? And she went to work for Friedenthal in his office, and he told her to go fire Julie and get rid of that agency. And she went over and she said, no, she's doing a really good job. We don't want to get rid of that agency. Marilyn Simons came back and said, that's a good agency. We don't want to come back. And Friedenthal said, then you're fired. And he fired her. She only lasted in his administration about 2 months. But that was one of the only agencies I'm aware of that he got rid of. But that was an agency that actually did kind of what I'm talking about here. So we took that, we've expanded it, and we've done, I think, a different approach somewhat, but that was kind of what we patterned this after, because information is what we're trying to get to people.
Right.
We're trying to make sure that people know what is out there, what they need to participate in. And so that's why we created this.
Perfect.
Do you know if there's anyone else that does it for other agencies?
I don't, and to my knowledge, no. And that's why we've talked about expanding it, but then I also practice law full time, and so I don't have all the time that I need to do some of these
Exactly
things.
what you said, the state should be.
The state should be. This state should be, but again, what I have seen, and especially I've been in my law firm for 15 years now, focusing almost exclusively on water and natural resources. And there is a pretty dramatic shift, like I said, between the state employees now really see themselves as an arm of the federal government.
Oh, I'm sure.
And I get along with these people really well. I work well with the DEQ. I really do. I work well with the DEQ. I would prefer to work with the DEQ. But most of the time when I'm talking to them, their response to me is, we have to do it this way because it's what the federal government says we have to do. The Hamilton case that I talked about a little while ago, where my client moved the irrigation ditch, that's something else that I think is happening, is I think that these federal agencies are taking test cases.
Yep.
They're doing these little tiny test cases out in the middle of nowhere, expecting that these people will not fight back. And if they can take jurisdiction over an irrigation ditch, it's pretty easy to take total jurisdiction over the Laramie River. Or, whatever creeks, Cottonwood Creek or something like that. Now, one of the things I get asked a lot about when I talk about the Clean Water Act and why I think that it's such a bad piece of legislation and it's being corrupted so much is people always say, well, don't you care about clean water? Why shouldn't the federal government have jurisdiction over this? My response to that is that it's the state that has the jurisdiction and authority over those smaller streams and should. Yes, sir.
The simple answer is yes. I love clean water, and clean water is too important to trust to the federal government.
And that is another very good answer. But the reality is, the people who are on Cottonwood Creek know a heck of a lot more about Cottonwood Creek than somebody in Cheyenne or Omaha, Nebraska, or Washington, D.C. It's just that simple. So,
And you're right on the test cases.
they're test cases.
That's what they do, because we were the test case here in Natrona County on property rights and grandfathered uses. Even though they knew it was real, they knew it's in the state laws, they know, that there has been cases fought on it. Camp was one of them that fought. He had a camping ground and they kept telling him he couldn't do it. And that's what they do, is they pick somebody they think can't fight them back. But then after we won, they know now that they're not going to get away with it. There is case law on it, and it's etched in stone.
Well, and I think that the EPA has backed off a little bit in Wyoming. You've heard about the guy in southwestern Wyoming that had the pond.
Andy?
Andy, when we had a meeting, when he was going to have a meeting with the EPA, he called me. I didn't charge him anything, but I think that his view was that they don't like me, and they're going to take the path of least resistance.
Uh-huh.
And I'm not all that easy to get along with. I used to be. I'm just not anymore. And they're going to take the path of least resistance.
How has that come out for him, do you know?
Pardon me?
How has it come out for him?
Well, so far, the EPA is not doing anything.
Good, good.
So we'll see how that turns out.
How much of the recent controversy down in Nevada with that rancher has to do with water and resources?
What else do you
in
guys have going
reality?
on?
Well, in reality, I think it all does. I think that was a Harry Reid deal. I don't trust anything that happened with that. The fact is, what shocked me about it, and I wasn't there, but what shocked me about it was, to me, that was nothing more than a dispute between two landowners, or a landowner and a lessee. The federal government being one landowner, and what's the
Yeah, I
gentleman's
just
name?
talked to her a couple weeks ago, she didn't say nothing.
I think it just got
Bundy.
started.
Bundy, and him being another landowner or lessee. What shocked me is that if I am leasing you property or we're neighbors, I don't oftentimes get to pull guns on you. And I can't use tasers. I go to court. If you're trespassing on my property, I go to court to get you off of my property. Or I go to court and demand damages for whatever you might have done. What shocked me was that the federal government actually engaged in self-help in that entire situation, where it was federal employees out there with tasers and guns. There was no place for that, and it should have scared every person in the United States to see an armed agency going after citizens of the United States. If he was wrong, bring a trespass action. That's easy. I mean, we do that all the time. They've got the federal courts on their side. What I was really stunned to see the level to which we had militarized our federal agencies.
Well, look at what's going on in Oregon.
They just afraid
They were scared.
of something that would be too embarrassing.
It was too embarrassing. I think that put them back. I think that it created a situation. It showed them for the thugs that they were, and I think that the federal government has backed down a little bit.
And you got the gold mine up in Oregon going on right now with the BLM.
Well, and I think that they are worried that there is enough of a powder keg. Going back to your comment, Jim, they recognize that people are tired of the federal government, whether they want to acknowledge it in Washington, D.C. or not. The people out in New Orleans and Jackson and places like that recognize that they have a different group of people involved now than they did 15 years ago. But our federal government's different now than it was 15 years ago. You know, I think that there's a kind of a siege mentality there. When I tried that case last year with David Hamilton, they wouldn't even put an E.P.A. guy on the stand to testify.
I love that.
So, I mean, they were too afraid. Not because I wasn't going to do anything other than humiliate him.
Well, that's your job, sweetheart. As far as I know.
They're not even trying to they didn't even try to defend their actions, and I think it's one of the reasons the jury ruled against them. No, I think that Bundy thing was helpful to us. It was an eye-opener for me. I did not expect that we would militarize agency personnel that have no business carrying guns on their hips. The very highest law enforcement official in that county was the sheriff, not the federal government. Under our form of government, the very highest official in that county was the sheriff.
Correct.
And I was pretty disappointed in him too. I mean, he needed to go in and say that, and I think he kind of took the side of the feds because he was afraid, but